Hello, my name is John Snow, and I'm with the law firm of Parsons, Bailey, and Latimer, which has offices in various Western states. And one of the things that I do for a living is practice law in courts. I'm what some people refer to as a litigator, although trial lawyer is a term that's kind of sometimes gets outmoded because we don't try cases as frequently as we used to. And speaking of what we used to do, we used to never worry about social media because when I first started practicing, this was not even a concept. But over the last 10, 15 years, or maybe even longer than that, evidence and introduction of evidence regarding social media has become more and more significant. And today's presentation is going to be on the use of electronic evidence. And it's not going to necessarily be the technical aspects of obtaining the evidence for its introduction. It's going to be some of the evidentiary rules that relate to the introduction of social media and how you lay a foundation, how does it come in. So first of all, what is social media when we use that term for purposes of analyzing it under the rules of evidence? And the first is that social media is any digital tool that allows the user to create and share content with the public. In other words, it's one person sharing, or one person or one company sharing information to the public generally. They all have their own specialized purpose or function. For example, Twitter is sharing links and short messages. Instagram and TikTok are built to optimize the sharing of photos and videos. It is estimated that there are 3.5 billion daily users of social media. That's 45% of the world's population. And the significance of that, to keep in mind, is when you're doing discovery, think about social media. Where has this person you're deposing, or your opponent, or this witness likely to have broadcast on social media about the facts relevant to this litigation? Now, of course, the easy one, the most obvious one, is the plaintiffs who have been involved in some type of accident and are injured, and then they start posting on their Facebook account pictures of them playing volleyball or basketball and doing things that they've just testified that they can't do. You can find those types of things on social media. You can also find advertisements of sorts by companies touting product that later fails. And you can use those representations contained in those social media publications, like advertising, to show contradictions in their current position about what the product can and cannot do. But when you have that many people using social media, you know that that is a good source of information that can work adversely against your client. In the slide, there's going to be showing how different users, and one of the things that is important is that 90% of millennials, people born in the 80s and 90s, use social media, but even baby boomers who were born between World War II and the mid-60s, 48% of those people still use social media. Even though those are generally older people and may not have all of the technological skills, they do use things like Facebook and some of the more basic social media outlet. And then the average user spends 3 hours a day. Now, these are individuals, of course, but as I stated, entities and companies and corporations use these social media outlets on a regular basis. Social media is unique because it broadcasts are relatively uncensored. So you can have a person make a broadcast and say almost anything they want, even if it's harmful to their case, because they don't associate their lawsuit with their broadcasting on social media.